Your client has just told you that a dispute is brewing in their workplace. Tensions are rising and productivity is slipping. Both sides are entrenched, and you're left wondering, what's the best way for me to help my client resolve this dispute? I'm Alex Rubin, owner of Rubin Employment Law. Today, I'm talking about mediation, when it's the right choice for your client, and how to choose a mediator who will help your client resolve workplace conflicts effectively while protecting their business. So, when is mediation appropriate? Mediation can be effective in these 5 situations. Number 1, workplace harassment or discrimination claims that both sides prefer to settle privately. Number 2, disputes over non-compete or non-solicitation agreements. Number 3, internal conflicts among executives or managers that are disrupting business operations. Number 4, threats of legal action or actual lawsuits from employees or former employees who may be willing to negotiate. And finally, number 5, contract and family disputes, as well as any type of litigation. In fact, as you may already know, New Jersey and many other states have mandatory court-ordered mediation programs for most cases. Now, why should you and your client choose mediation over arbitration or litigation? Mediation is confidential, flexible, non-binding, and often quicker than arbitration or hashing it out in court. A skilled mediator can diffuse tension, guide constructive conversations, and find creative solutions that work for everyone. Plus, mediation provides the parties with the opportunity to resolve their issues while keeping control in their hands, rather than the hands of an arbitrator or a judge. So, what should you look for in a mediator? Choosing the right mediator is critical to the success of the process. Even with court-ordered mediations, the parties have the option to choose their own mediator, at least in New Jersey. Here are 3 considerations to keep in mind when choosing a mediator. Number 1, experience. Look for a mediator who has experience in the area of legal practice your client's dispute is in. Number 2, impartiality. A mediator must be neutral, with no ties to any of the parties. And number 3, problem-solving skills. A good mediator listens carefully. A good mediator is a good listener and also crafts solutions tailored to your client's needs that the other side will likely accept. Now, why should your client mediate sooner rather than later? Delaying mediation can lead to an escalation of conflicts, expensive employee turnover in the case of workplace disputes, and legal headaches. By addressing disputes early, your clients can minimize their risk and maintain a productive workplace. If your client is facing a workplace conflict and they're not sure whether mediation is the answer, let's talk. For more information on resolving workplace disputes through mediation, read our blog at alexrubinlaw.com/blog.